The American legal system rests on the principle that statutes enacted by legislatures carry equal weight and demand consistent application. Legislatures at every level pass hundreds of new laws each year, expanding the criminal and regulatory code with provisions that address emerging issues, respond to public concerns, or align with policy priorities from other jurisdictions. This process of accumulation creates an ever-growing body of rules that citizens are expected to follow. Yet the practical operation of these laws reveals a fundamental tension. Enforcement cannot be uniform because resources are finite, priorities shift, and human discretion intervenes at every stage. The result is a system in which many laws remain dormant while others receive vigorous attention, undermining the ideal of equal justice. This disparity arises not from deliberate conspiracy but from structural necessities. Police, prosecutors, and regulatory agencies must triage cases amid limited budgets, personnel, and time. Serious offenses involving violence or major economic harm typically receive priority, while technical violations or low-harm infractions often go unaddressed unless specific complaints arise. Citizens observe the selectivity daily, fostering skepticism about whether the law applies impartially. The proliferation of statutes, many of which employ broad or open-ended language, further amplifies the problem by granting officials wide latitude to interpret behavior as criminal. What begins as legislative activity intended to promote order ultimately produces a code so extensive that uniform enforcement becomes impossible. The consequences extend beyond mere inefficiency. When enforcement becomes discretionary, the rule of law risks transforming into rule by discretion. Citizens may face investigation or citation for conduct that fits within vague statutory terms, while comparable behavior elsewhere escapes scrutiny. This pattern erodes public confidence and highlights an asymmetry at the heart of American governance. The ease with which laws are created contrasts sharply with the difficulty of ensuring their even-handed application. Understanding this dynamic requires examining how legislative output, enforcement mechanisms, and institutional safeguards interact to sustain the current equilibrium. Legislative expansion and the accumulation of statutes. Legislatures in the United States exercise broad authority to enact statutes, appropriate funds, and establish new agencies or programs. A simple majority vote suffices to pass most measures, including budgets that allocate resources for enforcement or create regulatory bodies. Once enacted, these laws and spending decisions take effect unless checked by executive veto or judicial review. The process favors rapid expansion because new legislation can be introduced and advanced with relative speed, often drawing on model provisions developed elsewhere. This yearly cycle steadily enlarges the body of law, layering fresh requirements onto existing frameworks without systematic pruning of obsolete or overlapping provisions. Budgets passed alongside substantive laws enable the funding of initiatives that may appear unnecessary or marginal to segments of the public. Contracts for program implementation can flow to connected parties, generating returns that sustain lobbying efforts aimed at preserving or expanding the same programs. Such arrangements create self-reinforcing cycles in which funded entities advocate for continued appropriations, ensuring the flow of resources. The result is a government apparatus that grows incrementally, with each legislative session adding to the stock of rules and expenditures that officials must administer. This expansion contributes directly to over-criminalization. With more statutes on the books, the potential scope of government authority widens. Many new laws address complex social or economic issues, yet their practical impact depends on enforcement choices made downstream. The accumulation itself becomes self-perpetuating, as legislators respond to perceived gaps or public demands by crafting additional measures rather than revisiting the existing code. The system therefore favors legislative productivity over consolidation, producing a legal landscape in which citizens navigate an increasingly dense thicket of obligations. Jurisdictional overlaps and concurrent enforcement authority. Law enforcement authority in the United States operates across multiple layers of government, each possessing distinct but frequently overlapping powers. Local agencies enforce municipal ordinances and state criminal laws within city limits. County sheriffs and their deputies exercise authority over unincorporated areas and retain concurrent power to enforce state laws throughout the county. State police or highway patrol units hold statewide jurisdiction, enabling them to address violations anywhere within the state's borders. Federal agencies focus on matters involving federal statutes, such as interstate commerce or offenses on federal property, yet cooperation across levels is routine. Concurrent jurisdiction allows multiple agencies to respond to the same conduct when it violates laws at different sovereign levels. A single incident may simultaneously breach state and federal provisions, permitting independent investigations and prosecutions under the dual sovereignty doctrine. Task forces that combine officers from local, state, and federal agencies further blur jurisdictional lines, enabling cross-deputization and shared operations. This flexibility promotes efficient responses to complex crimes but also multiplies the avenues through which enforcement discretion operates. An action observable by any sworn officer can trigger scrutiny regardless of which agency arrives first. The layered structure reinforces selective enforcement. Agencies prioritize cases according to internal policies, available resources, and political signals embedded in budgetary decisions. Routine matters remain at the lowest jurisdictional level, while serious or multi-jurisdictional offenses draw higher-level involvement. Citizens therefore encounter enforcement that feels inconsistent because the same underlying behavior may receive attention from one agency but not another, depending on location, timing, and departmental priorities. The system's design for cooperation thus simultaneously enables both effective policing and uneven application of the law. Vague statutory language, citizen reporting, and risks of police interaction. Many statutes employ broad or open-ended phrasing that grants officials substantial interpretive discretion. Terms such as breach of the peace, disorderly conduct, or negligent behavior encompass a wide range of actions, allowing officers to frame everyday conduct as violative when circumstances warrant. Traffic and pedestrian regulations similarly rest on officer judgment about what constitutes reasonable or safe behavior. This linguistic breadth lowers the threshold for initiating contact or investigation, enabling enforcement to adapt to situational demands but also inviting selective application. Citizens retain the ability to report observed violations, thereby initiating official scrutiny. Reports of suspected crimes prompt responses from the appropriate agency, and good faith accounts do not expose the reporter to liability. Yet the same broad statutes that facilitate reporting can be turned against the reporter. Officers arriving at a scene may cite the complainant for ancillary violations visible on site, such as property maintenance issues or elevated voices during the interaction. The risk of additional charges creates hesitation, particularly when the original report involves minor or contested matters. Many individuals weigh the potential hassle against the benefit and choose not to call. Police interactions therefore carry inherent uncertainties. Officers possess statutory authority to detain individuals upon reasonable suspicion and to use reasonable force to effect lawful arrests or maintain control. Physical commands necessary for safety must be obeyed, while certain investigative requests remain voluntary. The combination of discretion, vague language, and the potential for escalation generates caution among the public. Citizens learn that engaging the system can expose them to scrutiny even when they occupy the role of victim or witness, further diminishing willingness to participate in enforcement. Qualified immunity, official deception, and mechanisms of systemic self-protection. Qualified immunity shields government officials from personal civil liability in suits alleging constitutional violations. The doctrine originates from judicial interpretation of federal civil rights statutes, rather than explicit legislative text. It limits recovery to cases in which the violated right was clearly established at the time of the conduct. This precedent-based protection applies across federal claims and influences the practical accountability of officers and other officials. Attempts to remove or codify the doctrine have repeatedly stalled in legislative bodies. Officials also exercise considerable latitude to employ deception during investigations and public communications. Courts permit misleading statements intended to elicit compliance or gather evidence, provided they do not produce involuntary confessions. In policy announcements and crisis messaging, elected and appointed figures may advance claims later shown to be inaccurate or incomplete. Such statements can secure public adherence to rules, yet those who resist compliance may face enforcement actions. The asymmetry places citizens at greater risk when official narratives prove flawed. Even when a new administration assumes power and seeks to investigate predecessors, systemic barriers persist. Judicial precedent remains binding until overturned by higher courts. Legislatures can enact retroactive protections or adjust procedural rules. Prosecutorial discretion allows new officials to decline pursuit of past cases. Resource constraints and political considerations further discourage sweeping accountability. The result is a government that insulates itself through precedent, legislation, and institutional inertia, rendering wholesale criminal reckoning against prior officeholders structurally arduous. Conclusion: America's laws keep growing but enforcement remains selective. The American legal order exhibits a persistent tension between the volume of enacted law and the selective character of its enforcement. Legislatures generate statutes at a steady pace, expanding regulatory reach and creating new obligations. Enforcement agencies, operating under concurrent jurisdictions and broad discretionary powers, apply these laws unevenly according to resource limits and institutional priorities. Vague statutory language magnifies the scope of official judgment, enabling both responsive policing and arbitrary application. Citizen engagement with the system carries inherent risks. Reporting suspected violations can invite reciprocal scrutiny under the same expansive provisions. Police authority to detain, employ reasonable force, and issue commands rests on clear statutory foundations, yet interactions frequently expose individuals to ancillary citations or escalated encounters. Qualified immunity and the latitude for official deception compound the imbalance, limiting civil recourse and permitting misleading communications that shape compliance without corresponding accountability. Ultimately, the architecture of governance favors self-preservation. Legislative majorities can create protective measures, judicial precedent constrains challenges, and executive discretion determines which cases advance. Meaningful reform requires coordinated shifts across branches and sustained effort over time. The pattern reveals a system in which the creation and enforcement of law remain more accessible to those who wield power than the mechanisms for holding them to account. This structural feature defines the contemporary American experience of law and authority.